the advertising, which is quite strict in Russia, and unfair competition. Other than that, counterfeiting is one of his specializations, and he has successfully represented a number of companies from South Korea, Japan, Israel, and Europe. And he regularly speaks at some of our multinational events also. Next to me is Yuri Kuznetsov. He's the head of our patent practice, partner of Garodisky and Partners.
It was also, very successfully done, and was met with very high enthusiasm from this side of the listeners. So India indeed is a very interesting and of course prospective partner for Russia, and this is certainly because India is a partner in Russia with a sort of political formation which name is BRICS. You know about that. BRICS is expanding now, and what brings more opportunities for cooperation to the countries not bordering like the European countries in the European community, but countries which have relatively similar level of development. I would say alike cultural approaches or cultural heritage, and many more other, I would say, comparatively similar features. And with that, India appears to be very interesting for Russian businesses, and similarly we think that Russia should be interesting for Indian businesses, and therefore we did this presentation based on the success of the presentation that I mentioned on Indian practice. So it's not exact mirroring that presentation, but it goes through the same concepts and brings you more knowledge, basic knowledge about Russia, about the legal system of Russia, about the patent systems to be exact. You will soon know why I'm putting this in plural, which you may use for you protecting your IP rights in Russia. So with all that, let me start this presentation and pass the floor and time to Mr. Anand Saini, who is our director of our Dubna sub-office near Moscow. And then we will go across the presentation from the basic economic and political knowledge to the special features which will be presented by Mr. Melnikov on the legal system, and particularly on the legislation on service invention, which is in significant difference from what you have in India. And then Dmitry Klimenko will provide you with a necessary comparative study about two systems, patent systems, which you can use to obtain protection for your invention across the territory of Russian Federation. So Anand, please.
We wanted to talk about Russia and how it developed during the past few centuries, how the technical development went, how the cooperation with Russia, the Russia Indo-Russian Collaboration, how it went, and what are the indicators which are telling us that the development is going on between two countries. If we see at the slide over here, we can say that eighth economy in the world. It used to be fifth, but now it's dragged down to the eighth. You know the reasons. And then next, when we could talk about the demography, it's like 140 million people, and over 500% of this, 50% of these people are in the labor market. When we talk about the industry, we know that there are quite a big number of industries where we are highly penetrating the market. So we are talking about the defense, the automotive, and the aerospace industry. Then again, ONG it remains as the primary section, which brings most of the revenues uh, to the budget. Information technology has been quite a growing market since last few years, and there's a good growth of 30 to 40% in a year. So that's quite interesting figure over here. Now, when we talk about the industrialization, we understand that it all started not yesterday. It started just when the whole industrialization of the world just started. And at the beginning, it was all again the primary markets, which was like agriculture. Then we did mining, and we had which developed a little more to the materials, going to the raw materials, the steel production, and then the chemical industry came into the place. And then when we talk about the factors which lead to the industrialization is quite common to each and every country which underwent this revolution. Then we talk about the growing demand inside the country. Then we have the availability of raw materials, which was brought forward by to the production people. Then the people got support from the government, and second, and not the least is, but most important comes as the availability of the transportation. So once you make the goods, you can deliver it. So all these kind of things led to the industrial revolution. So what was the positive sides of this industrial revolution? Yeah, you got the growth, you got the urban population moving, you got the people moving from the villages to the cities, then you got the more educational properties, more work, more income. But at the same time, we still had the minuses. Then we sent the social integrity. When you see that the people are in the villages are poor than the people who are in the cities, then the working conditions, as always, during the beginning of the all industrial revolution, working conditions were not the best. Then we had the problem with the child labor at the same time. And when did the cooperation between the two countries really started? So it was in 1970s when there was a Indo-Pakistan war, and after that the USSR signed up a pact, or we can the treaty of peace, friendship, and cooperation. The main technological cooperation, as we know, between the two countries were based on the atomic energy, aircrafts, agriculture. Then we had the space, and defense system still remains as one of the leading factors of the technological cooperation. Here in the slide, there's a little bit information about the number of in the numbers, you can see that the export and imports are growing quite interestingly. In last 2022, I think it was close to $2 billion, and importing at the same time over the $30 billion. So what India was importing mostly, it was oil, fertilizers, petroleum products, and gems. When we talk about what we are receiving from India, we can talk about, again, oil products, something, I mean, this is what we are exporting towards India is the nuclear technology. Then the military cooperation still remains as one of the leading export item. When we talk about availability of Russian companies in the Indian market, we can see that along with the government corporations or companies, we also have private companies, banks, which are also working in India. AFK system is one of the main stakeholder of Satyam Telesystems. Technonicol is one of the construction companies which is making their factories for the construction materials. At the same time, when we look back towards Russia, then we can see that there are Indian companies who are also working in Russia. They are expanding their business, making big plants, some pharmaceutical products. Some of them are making pipelines, oil and gas stuff. So these are also in the main business areas of our cooperation. Well, if you will take a look at the Russian patent system, I mean, just in a brief, because Dmitry will give more detailed information about this. So it all started with the Royal Manifest of 1812, and since then it's undergoing several changes, and last one was in 2023. And well, basically you have to enter Russia with a patent, you have three options. You can go through the PCT, you can go to the conventional application in Russia, or you can go through the Eurasian patent regional filing. I think Dmitry will give us more details about this. Well, if you talk about the statistics, so it's not too far from what we see in India also. So close to 23,000 issued patents, and 65% are held by Russians. And as for today, there were about 8,000 foreign applications. Only 75 were from India, and from Russia, 101 application was filed in India. Well, if we take a look at the patent statistics, then we can see that the field of inventions are almost the same, but if in India we can see a big raise in the biomedicals and the biosciences. So in Russia we don't really see much going on here, but yeah, we are deep into the surgery, IT sector, metallurgy. So this is all included. Well, when we talk about features of retracting Russian, I'll just start with a little bit. So, for chance, some companies, Indian companies, are interested in setting up their business outside India, for example, in Russia. So there are some factors when you have to invite the local representatives and local specialists to work in Russia. So there are basic forms of companies which are available. It's like the individual entrepreneurs, it's the limited liability companies, and then you have the corporations, the joint ventures, and the partnerships, which are also quite common in Russia.
In this section of our presentation, we are going to cover some issues relating to corporate law, labor law, and intellectual property, and all these issues are necessary to know when you are going to do business in Russia, especially when we are going to get some intellectual property in Russia. So we have the standard set of legal forms in Russia. I believe that Indian legislation provides the same. You can do business as individual entrepreneur. However, it might not be a good form for foreign companies. And the most popular form in Russia and for foreign companies doing business in Russia is a limited liability company. It is really easy to incorporate this legal entity. It is really easy to maintain and comply with all requirements provided by the Russian legislation. I would like to know that many and maybe most of our foreign clients prefer to incorporate their business in this legal form. We also have corporations. We have two kinds of corporations, closed and public corporation. But this legal form is designed for maybe the most, for large ventures, for large projects. And it is more difficult to incorporate such legal entity and to comply with all requirements applicable to corporations. We it is also possible to form partnership, but the main disadvantage of partnership that it is partnerships unlimited liability. So your creditors can come to you and claim debts from your property. Отлично. So there are some features of the Russian staff. We would like to note that Russian specialists are really highly qualified. There are the time zone compatibility. There is no the significant time difference between India and Russia, and there is a diverse skill set among Russian specialists. So it might be necessary to know requirements applicable to established by the labor law, and I believe that India has the same set of requirements. So we have minimum salary standard. We have some requirements relating to work schedule and overtime. We have a set of leaves applicable to employees, including maternity leave. And we have the standard of equal pay for equal work. This standard is established in the Russian legislations. And we have specific vacation and non-working days. For instance, we have very long the New Year holiday, which lasts for usually for 10 days. And we have strict regulations related to safety and health security of our employees. So the employees are also entitled to social security, and employers need to submit some payments to social insurance funds. The employers has right to information. They can form trade unions, and they are protected from discrimination by the law. So, and maybe the most interesting issue is the service invention. We have the hire to invent doctrine fully implemented into our legislation, and we have a significant case law on this issue. So there are three parts of this section. First of all, we need to understand what employees' invention is, what might be the risk of losing employees' intellectual property, and how the intellectual property can be assigned to any third party. So there is a definition of the service invention provided by the Russian Civil Code, and the crucial part of this definition is that the invention should be created in the course of employment. So, and of course, the question is what is the employment and how it should be defined. It was noting that under the Russian legislation, only a natural person can be designated as an inventor, so the legal entity cannot be designated as an inventor. This means that in any case, your employees should be identified as inventors in the patent application. However, with respect to the service invention, the exclusive rights, all inventive rights belong to the employer, unless otherwise is established in the agreement. So you can change this default rule provided by the Civil Code. The same rules are applicable to all other industrial property, to utility models and industrial designs. And the question, what makes an invention as a service invention? And the answer to this question is employment documents, which should be executed according to the applicable requirements. Why it is important? Because in case of a dispute with your employee, the burden of proof is imposed on the employer. It means that in case of a dispute, the employer should prove that a particular invention was created in the course of employment. And to do so, the employer should provide the court with the full set of documents confirming that this particular invention was created in the course of the employment. So we have interpretation provided by our Supreme Court, which said that the criteria of employment can be established in the relatively general range of work functions, or it can be defined in a specific task. It means that it can be defined in the policy, in the key documents relating to employment. So, and this slide says list the said key documents. We can start with the policy regulation on the intellectual property, which can provide general definition, general rules applicable in your company, applicable to intellectual property created in your company. So it's also reasonable to have regulation on trade secret. Why it is so? Because the employer can file a patent application. On the other hand, the employer can keep the service invention as a trade secret, not to disclose this invention to the public. In such a situation, you need to have regulation on the trade secret in your company. And it's also reasonable to have employees' task on or plan of development with respect to particular, for instance, you would like to develop a medicine, and it's reasonable to have some documents how this medicine should be developed and who are responsible for development. All these documents can be used in court in case of a dispute. So the next document is the employment contract, is the key document with your employee, and this contract should include some provision with respect to intellectual property. For instance, my employment contract with Городиский and partner includes such provision, and everything I can create while my employment belongs to Городиский and partners. The next document is job description. Actually, it's the list of the employees' duties. I have the same, and it is stored in the Городиский's files in case of a dispute. And it's also reasonable to have a contract on payment of a service invention. Why it is necessary? Because even if the employer has, when the employer has the right to the service invention, the employer should pay additional compensation to the employee. And the amount of compensation as well as the term of payment should be defined in the contract. Otherwise, the set terms will be defined by the court. That is not preferable. It is not preferable to have the court case. That is why it is reasonable to set the set terms in the contract on payment for service invention. So the case law provides some recommendation to law courts what facts should be noted, what facts should be examined by the courts to decide whether the service invention is a service one or not. So the court should review area of business, scope of work duties to compare these two facts, place of creation, materials and resources used for invention, employer's control over development, purpose of the invention, communication between the employer and employees. And it was noting that this communication can be done in the electronic form, and the Russian courts accept such evidence and consider this evidence as eligible. And of course, the court should review employers' paperwork, if any. And what is the free invention? Is the invention which is which is created out of the scope of duties, or the invention that is not claimed by the employer as service one. So the second option is about the situation when the employer is not interested in this invention and does not assert its rights. So all such inventions, all rights to such inventions belong to the employee. And the situation our legislation provides regulation with respect to the situation when the employee created something and using employers' materials, equipment, or resources. And our legislation states that the mere fact of using resources, employers' resources, does not constitute any rights on the side of the employer. So there might be other documents, other facts to evidence that this particular invention was created in the course of employment. At the same time, employer in such situation, although the employer does not have the exclusive right to this invention, the employer has two options how to proceed. The first option is to claim a non-exclusive license and for using this invention within the employer business. At the same time, this license is not transferable, and in such a situation, invention can be used only in the employer's business. Or if the employer is not interested in this invention, the employer can claim compensation for the resources, equipment, and funds used by the employee. So our legislation provides the order how the invention can become a service fund. So if the employer believes that something is created, the employer should notify the employer on the invention. After the notification is made, the employer has two options: to assert, to accept this invention, and to accept this invention, the employer should make one of the three steps. So the employer can file the patent application to transfer the right to a third party, or to inform the employee about keeping this invention in secret. In such a case, it is considered that the employer has accepted the service invention and has asserted its right. If no decision made, the exclusive right is deemed returned to the employer. Therefore, the employer loses its right to the invention. However, even in such situation, the employer retains the right for a non-exclusive license, provided that royalty for this license is paid to the employee. The royalty can be agreed in the contract or should be defined by the court. That is why it is necessary to have the contract, a separate contract on the compensation that needs to be paid in such situation, to avoid having the case submitted to the court. The compensation shall be paid to the employer if the employer has got the patent, decided to keep the invention a trade secret, assigned the right to file a patent application, or failed to get the patent due to its own failure. As I said, the amount and payment terms are decided by the agreement or by the court. The right for compensation cannot be assigned, however, it can be inherited. In case the patent is assigned, the obligation to pay the compensation does not follow the patent. This means that the employer should keep paying the compensation for this invention. If there is no contract on the compensation, our courts award the following rates of the compensation, and these rates are established by the decree adopted by the Russian government. So for the invention, the employer should pay 30% of average salary. For industrial design and utility model, only 20% of average salary. There is another case when the employer should pay compensation, and this case when the service invention is used by the employer in its business. In such a case, if there is no contract for On compensation, the Russian government provides the following rates of the compensation: 3 average salaries for an invention and 2 average salary for utility model and industrial design. This slide says about some risk associated with service invention. So the first one is the risk of having co-authors. We have this situation in our law firm when one of employees of our client decided to seek some help on the side of his friend, and his friend provided some creative contribution to this invention. And it's necessary to note that any contribution, any creative contribution to the invention results in inventorship. Therefore, our client could face co-authorship with unknown person. And of course, it's reasonable to avoid such situation and to instruct employees not to seek any help, not to involve any people in the process of development and creation. So there are some court cases when the court noted that there are some failures to meet requirements established by the Russian legislation. So the duty to create invention in the job description, as I said, it is really essential to have such provisions in your local documents as well as the contracts with your employees. So if there is no content of the employee request or target specification for development, this fact can also affect the employer rights to invention. And it is also necessary to have the proper wording of the employment documents, the wording which corresponds to the provision established by the Russian legislation. So the rights can be the right to the IP, to the intellectual property can be assigned. There is another way, which is to purchase of stock and shares in the company and to purchase the company as a property complex. So it's worth noting that if you create invention in Russia, there is obligation for the patent owner, for the applicant to file the patent application in Russia first. If you do not comply with this requirement, this fact does not affect your right to this invention, and this fact does not affect the patentability of the invention. So violation of this order may constitute an administrative offense and can result in the fine of about $900 US. So, and we're moving to the next section of our presentation, and my colleague will provide.
Okay, I have good news for those who are following. We're only about 10 slides to the end. So, in my portion of the presentation, I'll quickly characterize for you Eurasian and Russian patent systems. Just like in Europe, you can get either a national patent following a national patent system or a European patent which covers a particular country. In Russia, there are also two options. You can either obtain a Russian national patent or a Eurasian patent which covers Russia among 8 other contracting states. The 8 contracting states are former republics of the Soviet Union. On this slide, I start listing the main features of the two patent systems. The prosecution is, I have to say that there are more similarities than differences between the two patent systems. So we have electronic prosecution in both cases. All transactions are paperless. We don't send or receive any paper. For your PCT application, both offices are receiving offices, also international searching authorities and international preliminary examination authorities. And you can enter you can enter a regional or national phase in Russia and Eurasia. The two patent offices have specialized examination divisions for particular kinds of subject matter. For example, I'm a life sciences guy, so life sciences inventions are examined by as many as 3 different departments: pharmaceutics and chemistry, biotechnology, and medicine. And the clients are represented before the patent offices by registered Russian and Eurasian patent attorneys, which are obligatory for non-residents and foreigners. The patent term is 20 years from the filing date in both cases, and for a number of subject matters the marketing of which requires obtaining a marketing authorization, there is a patent term extension, PTE, like for drugs, pesticides, and agrochemicals. The formula you're probably familiar with is that the difference between filing date and first MA date reduced by 5 years, and the maximal term is 5 years. In the Russian case, you get a supplementary patent. In the Eurasian case, you get whichever document is issued by the national procedure. So you get your patent extended following national procedures in the EA contracting states. There's also a grace period in both cases for disclosure of the invention by the author, inventor, or whoever obtained that information from them. It is 6 months before the filing date in the Russian case, and 6 months before the filing date or priority date in the Eurasian case. In both cases, there is a mandatory search before substantive examination. Also, voluntary amendments are possible in both cases. In Eurasia, you can file voluntary amendments whenever you wish before the allowance. In the Russian case, there are particular moments when you can do that. You can also file divisional applications. Then both patent offices are partners with many other patent offices as far as PPH program is concerned. And last but not least, method of treatment are available in both. Couple of definitions. So in the Russian case, the invention is a technical solution in any field relating to product or process, including use thereof. In Eurasian case, it is a material object or process created or transformed by humans, in particular device, method, etc. Exceptions are pretty much the same as an Indian case. I just noted down a couple of differences. So unlike India, in Russia and Eurasia, inventions relating to atomic energy are patentable. And also Russian legislation makes specific note of the following exceptions: that methods of cloning humans and human clones, methods of modifying genetic integrity, and use of human embryos for industrial and commercial purposes cannot be patented. In case of such inventions, you may receive a note from the examiner asking to get rid of those features from the patent claims or add an appropriate disclaimer. Okay, this is my hello to patent people. This is an intentionally crowded slide, but it lists the principal features of life of an application in the two cases. I'll take you through it. So both jurisdictions are 31-month jurisdictions for entering the national phase. Then once you're done with formal examination, in Russia you request substantive examination within 3 years from the national from the filing date. In the Eurasian case, you get to do it during 6 months from receiving the search report. So in both cases, as I already mentioned, you have a mandatory search. Then in the Russian case, you have up to 3 office actions, and the third one being a final one, not extendable one, upon receiving a response to which the examiner issues a decision to refuse granting or to grant. In the Eurasian case, you normally have 3 office actions, but may have more. They are longer as far as the term for responding is concerned, and also the extension period is unlimited. Of course, the official fee is escalating for that. So, and you get a notice of readiness to grant or decision to refuse granting. And in the green bar, I put down the most important requirements which have to be met: unity, 3 patentability conditions, and sufficiency of disclosure of the essence of the invention. So, for those who are not satisfied with the decisions made by the patent offices, there is an option of appealing against the decision. In the Russian case, it is a Chamber of Patent Disputes. In the Eurasian case, Board of Examiners. If, for those who are still not happy with the decision, there is an IP court in the Russian case. In the Eurasian case, it is President of the APO, and his decision is final. Opposition, pretty much the same thing. The patent can be invalidated partially or fully. In Russia, you go to the Chamber of Patent Disputes and then to the IP court. And in the Eurasian case, you have two options. One is called administrative invalidation, which can be done during 3 years since the grant, in which case you invalidate or partially invalidate the patent in all the EA countries altogether. In the other case, you can just follow the national procedures. And this brings me to my last slide, Russia or Eurasia. We get this question a lot, and here I put down a number of things to consider. Business interests, obviously. Are you interested in patenting only in Russia or in some other countries of the Eurasian Convention? Also, costs versus gain. Of course, the official fees are definitely higher in Eurasia, but in return you get 8 countries instead of 1. And also, for example, you have the opportunity to extend the substantive examination for as long as you want, just by filing for an extension of the term. And last but not least, over the last years, the Russian Patent Office have developed some peculiar approaches towards examining polymorphs like crystals of pharmaceutical compounds, selection inventions, and computer-implemented inventions. To cut a long story short, it's probably easier to get patents for those kinds of inventions in Eurasia than in Russia. So this concludes my portion of the presentation. Thank you, and I give the floor back to our moderators.
Thank you, Dmitry, and this completes the whole hour presentation today. We ended it exactly as the organizer asked us to do at 3:30. So we have a stand in the lobby or whatever is there near the conference area. So please feel free to come and to precise whatever other matters you want to discuss with us. We are here for the whole conference, so feel free to come and to discuss and to ask more questions. Thank you very much.
So that's the best way to learn, file your own patent and get the protection each way. So thank you so much. Sincere gratitude to our panelists for being the driving force, successful, insightful session, and also expressing gratitude to our moderator for the adept navigation, a seamless, engaging discussion, and finishing on time. Thank you so much. I'd like to present a memento.